Welcome to rePROs Fight Back, a podcast on all things repro. I'm your host, Jenny Wetter, and each episode I will be taking you to the front lines of the escalating fight over our sexual and reproductive health and rights at home and abroad. Each episode, I will be speaking with leaders who are fighting to protect our reproductive health and rights, to ensure that no one's reproductive health depends on where they live. It's time for rePROs to fight back. Hi, everybody, and welcome to this week's episode of rePROs Fight Back. I'm your host, Jenny Wetter, and it's October. It means it's getting cold out, the leaves are changing, it's college football season, go Badgers, and it also means the Supreme Court is back in session. And this term, that means they're going to be looking at cases impacting LGBTQ rights and reproductive rights. They've already started. They've already heard their first cases on LGBTQ rights. So this episode, we're going to talk about the cases that they've already heard, and we're going to look forward to talking about the reproductive rights case that they have already decided to hear in the spring. So helping me dig into that, I couldn't think of a better person to have than Katelyn Burns, a freelance reporter who you may recognize from an episode we did earlier this summer on trans rights are human rights. Katelyn was the first trans reporter covering Capitol Hill, and I'm so excited to have Katelyn with us today to help dissect all these issues. Hi, Katelyn. Thank you so much for being here.
Thanks for having me on again.
So, like I just said in my intro, that the Supreme Court has already started, and they have already started looking at cases that could have major implications for LGBTQ rights. Do you want to talk a little bit about some of those cases before we talk about how arguments went?
Yeah. So last week, the Supreme Court had oral arguments, and you'll have to forgive me, the names of the cases escape me. But basically, there are three separate cases. Two of them were combined, and those had to do with LGB rights, so lesbian, bisexual, and gay rights, and whether or not it's legal for an employer to fire somebody for being LGB. So that was one set of cases. That was two cases combined into one. And then the second case was the same question, but applied to trans people. So is it legally permissible under sex discrimination law to fire a trans person for being trans? So those are the questions that the Supreme Court are dealing with. But just a little bit of detail on the cases themselves. On the LGB side, and I have trouble shortening the acronym, so I apologize. There was a skydiving instructor who was fired after disclosing to a client that he was gay. And you'll have to forgive me, I don't remember the exact details on the second case, but it was something very similar to that. So the argument is whether Title VII of the Civil Rights Act of 1964 applies to LGBT people. As originally written or interpreted back in the 60s and 70s, you know, that wasn't on anybody's radar. But if you actually read the text, which basically says that discrimination in employment decisions cannot be made on because of sex. If you look at the plain language of it, it seems pretty clear that sex is at least a partial motivator, which the courts have consistently found to interpret as being included under the law. And in the trans case, I have a little bit more familiarity with that because I've been covering it more closely as a trans reporter. But that involved Amy Stevens, who is a funeral home director and embalmer at Harris Funeral Homes in Michigan. And she came out as trans. She gave her employer a letter saying, you know, I'm planning to change my name to Amy and live the rest of my life as female, and gave the letter to her employer. The employer read it, said, okay, thank you. And then about 2 weeks later said, yeah, this isn't going to work out, and got rid of her. And I actually interviewed her on Monday of last week, which was the day before the arguments. And
which everybody needs to go read.
It's on Vox.
And that's Vox with a V, not F.
Yeah, I don't write for the F'ers. Oh my God, that's pretty funny.
It's just one of those, you hear it and sometimes you don't immediately think. You just need to clarify that it's Vox with a V.
With a V, not the F'ers.
Yes, exactly.
And, she basically said that she got really mad when that happened. And she decided to fight back and filed a claim with Equal Employment Opportunity Commission, close enough, the EEOC, who pressed the claim in court. So the interesting thing that happened was, I believe the case started under the Obama administration, where the EEOC fully supported her case and the entirety of the federal government, and now under the Trump administration, who is explicitly anti-trans, which we've talked about before. Yes. There's been some interesting politics. Can I get into this really quick?
Sure.
Yeah. So the interesting politics of this is the White House tried to get the EEOC to drop their claim. And the EEOC, like career people, basically said, no, we're not going to do that, because the EEOC is actually an independent commission. They basically thumbed their nose at the White House. This leads into what happened at arguments. So an interesting dynamic at argument was when EEOC cases reach the Supreme Court, the Solicitor General takes over arguments from the agency. The case is actually Harris Funeral Homes versus the EEOC. And you ended up having the Solicitor General of the United States arguing on behalf of the EEOC, saying that the EEOC should lose the lawsuit. It was
that's wild.
Pretty ridiculous.
Yeah.
And then, just as an aside, I covered the oral arguments. I was inside the press gallery, and I was flanked by legal reporters, right? So not popular news sites like I was writing for,
right.
Again, with Vox with a V, not an F. And the guy next to me was making a joke about how the honorific for the Solicitor General is General. So when he got up to argue, they said, that Chief Justice Roberts was like, General? And my entire row just started cracking up because we were just talking about that 10 minutes earlier.
I didn't know that.
Yeah.
I guess I wouldn't have thought of that, because then you would refer to them as General.
Right. But he's just an attorney. He's not an actual general.
Nice. It's somehow so perfectly 2019 that we're arguing about LGBTQ rights in such a fundamental way as to if you can be fired because of that, because mostly that is the wildest thing, right? That people are doing that. And two, it's completely of course, in 2019, we're still having that argument in other ways because we're arguing about everything basic right now.
On the legal side of things, there's, I believe it's 23 states have state-level protections protecting LGBT people from employment discrimination. And I can't quote those numbers exactly because some states have LGBT protections and no trans protections. I think there's another state that has trans protections but not LGBT, so it's a hodgepodge of local laws. But there actually is no explicit federal law that bans this type of discrimination. But what we've been seeing in the courts is taking a statutory reading of the law that employment decisions cannot be made because of sex. We've had, I think, 5 circuits which have ruled that Title VII does apply to LGBT people. And we've had one circuit, and I don't remember which one it is. I want to say maybe the 11th, that said, no, it doesn't apply. So that's where you get the split. That's why it's in front of the Supreme Court now. And it's an interesting case. It's statutory law, not constitutional. So it's somewhat lower stakes for the LGBT community. I think a constitutional question would be scarier because constitutionality can overrule anything Congress does in the future. So we don't want that kind of precedent. But if it's statutory in nature, Congress can always change it. Again, keeping in mind that Congress never changes anything.
Yeah.
But all of this could end tomorrow if Mitch McConnell would just hold a vote on the Equality Act.
Oh, that's still going to happen.
And, I mean, we'd have to have a White House that wouldn't veto it, but still.
Yeah. In theory.
Yeah.
So let's turn to the arguments. So what happened? I guess it'll be a couple, maybe 2 weeks ago when this comes out, but yeah.
So there was an hour each for arguments, right? So each side had basically a half an hour, which is kind of wild when you step back and think about these are fairly huge, complicated issues that only get an hour time, and none of the justices are LGBT themselves. So you have 9 straight people who are making this decision, right?
Cis straight people.
I mean, there's not even a trans federal judge in the entire system. Not one.
I guess it's somewhat surprising / not surprising. Like, surprising and, like, again, it's 2019. There totally should be, but also...
Yeah. So, anyway, that was an aside. But
I
think the arguments went pretty well. I think on the LGBT side, I thought that the pro-queer attorney did a really good job. I think her case is a little bit harder to make just because just on the text of the law, you can technically make an argument that LGBT people aren't being fired because of their own sex, but because of the sex of their partners. The argument that she made was basically, and this is the one that I thought broke through, at least with me, even though I was biased going in, was you could have Bob and Sally are coworkers. And Sally can marry Bill and not be fired. And then Bob can marry Bill and would be fired. And that would be disparate treatment between the sexes.
Okay, that makes sense.
So if a woman can marry Bill, but a man can't marry Bill, the same person, that's disparate treatment. And it led to, Justice Alito just making some ridiculous, like he tried so hard to find a situation where you wouldn't know. So he took that argument and tried to make this ridiculous extension to it where he was like, okay, let's say we have a scenario where you have a hiring manager and then you have somebody who's doing all the vetting for the hiring manager. And they get to the hiring stage and they have two candidates and they don't say the sex of the two candidates, but they say one is gay and one is straight. You've now removed the applicant's sex from the equation. Is it still sex discrimination? And I think that tripped up the attorney arguing the case just a little bit, but it's completely ridiculous.
Right.
It's still, I mean, it's a reach. It's not a situation that happens. And she's like, that's not what happened in this case. Like, but you know, that's Alito for you.
Yeah. I would expect nothing less.
And then, so I think the trans case was also interesting. Again, I think this trans case is a little bit stronger because you are dealing with one person and their sex under the law, right? If I could just criticize the ACLU really quick, I didn't appreciate their framing of Amy Stevens as a, quote, insufficiently masculine male. They argued that they tried to equivocate between Amy Stevens and Ann Hopkins, who's the person in the precedent case, which was Hopkins v. Price Waterhouse, where, so Ann Hopkins was a butch woman. I've found out recently, not a lesbian, so a butch straight woman who was rough talking, did not wear skirts or dresses to the office, didn't wear makeup.
Wow, I always feel like I've heard it framed as that she was a butch lesbian.
Yeah, no. I was corrected on that recently. It's just butch, right? Right, exactly.
My head went there.
And what happened was Price Waterhouse denied Ann Hopkins promotions because they wanted her to dress more femininely, wear makeup, talk with a higher pitch to her voice, and be more feminine with her mannerisms and her speech. And the Supreme Court, years ago, decades ago, determined that that is discrimination because of sex stereotyping. So the ACLU turned around and used that case and said, basically, one thing that stuck out that they said was, if you take all of the same facts of the Ann Hopkins case, but make her a trans man, it wouldn't change the outcome of the case, which I understand why they made that argument. But what ended up happening was it walked the ACLU directly into the bathroom question. Because if this is an insufficiently masculine male, why can't they use the male bathroom? And that's exactly where it went. And it was really frustrating to me. I wrote another piece for Vox. I was really busy last week, expressing how frustrating it was to listen to those arguments and have, Justice Gorsuch claim that there would be a social upheaval, a massive social upheaval, he said, if we rule in favor of trans people in this case. And I had to go to the bathroom the entire time. I had to go to the bathroom before the trans case arguments started, but I wasn't going to leave. So I had to make a beeline for the bathroom as soon as it was over. But the Supreme Court's still standing. I walked by it on my way here.
Yeah. It didn't fall down.
What social upheaval is happening here? It's absolutely ridiculous to me.
The bathroom. I don't want to be around anybody. Like, just go and do your thing and leave.
Yeah,
like, I don't
exactly.
care who else is in there.
But I think the ACLU didn't help their case by saying she's an insufficiently masculine male. I think that might come back to bite everybody down the road. I think, and I'm not an attorney, but the attorneys that I've spoken with have told me that they would have gone about it in a different way. They would have really tried to educate the Supreme Court on why Amy Stevens' experience of womanhood is legitimate, and made the case that she was being discriminated against and the stereotype that she's defying is not being assigned female at birth, right? Mm-hmm. Being transitioned into womanhood instead of quote unquote being born into it. Because I think that opens up the law in a way that won't bite you coming back later. Okay. And if you look at the circuit case, I think it's the Sixth Circuit case for the Stevens side of things, that's exactly what her attorneys did there. And then for some reason they changed track at the Supreme Court. I'm not sure why. But in terms of how the arguments went, I think Gorsuch actually might be, if there's going to be a conservative that crosses the line and votes in favor of this case, I think it's going to be Gorsuch.
Which I found shocking that people were saying that.
Well, he's a hardcore textualist, right?
Okay.
So he goes by the text of the law, and he said in arguments, he's like, the textual basis of this is there. But he's like, my concern is the social upheaval that would happen from this, and is that better determined by Congress? And it's a question of judicial modesty. But I think the textualist side of him says, yeah, this actually makes sense to me. And it's like, it fits with how they wrote the law. And if they want to fix that law, then Congress can change it. And that's the way our system has been designed to do. I don't know that he has the guts to actually make that ruling. My gut tells me that either both cases are going to lose, or there's going to be a split with the trans case winning narrowly. I'd be very surprised if both cases won.
Okay.
And I think that social conservatives in general would be very, very upset if the trans case won. So I think there's a lot of pressure there on the conservatives to hold the line. I have my eye on Gorsuch and possibly Kavanaugh, because he's also somewhat textualist in his rulings. And I don't expect any of the other social conservatives to go that way. And I'd be surprised if one of the liberal judges voted against either case.
Yeah, it's kind of surprising to think that the trans case is the one that might win.
Right.
But also, like, when you describe it to me, I can see that. Like, right. I can see why that is a clearer story.
Yes.
For the context of Title VII.
Right. But if you look at, like, the state of our society
Correct.
now, the more palatable decision would be to rule in favor of LGBT rights
right.
and not trans rights. But sometimes the law doesn't work that way.
Yeah.
Right. And it shouldn't really work that way. I mean, both cases, honestly, should win.
Yes. I mean,
but we're not dealing with a legitimate...
I just can't wrap my head around that we're having a fight. I mean, I feel like I've said this on so many of these topics we've talked about, that I can't believe we're having this fight right now, that we're fighting that doctors should treat people who come into the hospital, that we're saying you can't fire somebody because of their sexual orientation or gender identity. Like, these are such basic things that I just cannot believe we're still having to fight over.
Yeah, and again, Congress can change it all tomorrow, and it would make this case...
The vehicle's there. It's
move.
past the House.
Yes.
Okay, so we talked about the cases and how the arguments went. Maybe a little bit about what would the implications be if they both lost?
The implication for a loss in both cases, I think, would be that, again, it's a statutory issue, so the pressure really goes to Congress, right?
Okay.
So if there was a loss in both, I'm really hoping that it will sort of galvanize a grassroots campaign to put pressure on Congress to pass the Equality Act. It's certainly not going to get passed and signed into law by this president.
Right. There are elections coming. So this could possibly turn this into an election issue, which both thrills me as a reporter and terrifies me as an LGBT person. For sure.
Yeah. And the other thing is to pass the Equality Act, even if we somehow take the White House and the Senate, we're still going to have to dump the filibuster to get it passed.
Yeah.
So when I hear, there's a debate the other night in those LGBT town halls last week, which again, I've covered for Vox. I don't work for them, but I write for them a lot. And when I hear these big ideas, no matter what it is, reproductive health, Medicare for all, the Equality Act, if I don't hear a candidate talking about filibuster reform, I tune it out because just process-wise, we're not going to have 60 Democratic senators anytime soon. So you need to figure out how to get these things passed with 51 votes. And the only way to do that is by dumping the filibuster. So a couple of nights ago during the debate, I kept screaming, filibuster, filibuster, filibuster. And finally, I think Liz Warren said something a couple times about it. And I was just like, yes, filibuster reform. And I pinned the tweet. But so that's the next step. That's the sort of meta-analysis of what happens after is it gets punted to Congress and we need to overcome a certain filibuster, even if we do somehow get a majority in the Senate.
Okay. So let's switch gears.
Yes.
So also that same week, I guess. Mm-hmm. Also, I just have to state it was kind of a wild day for me. It was a little emotional morning because I was literally sitting at my desk listening to the Daily from that day where they were talking about Christine Blasey Ford and what she went through to be able to testify and everything that happened. And literally, while I was already having a hard time listening to that, because that is kind of triggering and brings back a lot of things, is when I got the breaking news alert that the Supreme Court was going to pick up this abortion case. Mm-hmm. It was a rough morning.
Yeah, I bet.
It was just all at once. Anywho. So let's talk about that case. So it is June Medical Services versus Gee, and it's based out of Louisiana. Do you want to tell us a little bit about it?
Yeah, so I just made sure that I was on top of this on the way over here because I've been so focused on the LGBT cases.
Yeah, for sure.
So basically, this case is a carbon copy of a Whole Women's Health, I think, v. Texas. Hellerstedt, thank you. Sorry.
Yes, it was from
Texas. That's what it was. Which was, what was it, 2 years ago now that they ruled?
2 or 3.
Yeah, that they ruled.
Very recent.
So basically, the law in question is a requirement for abortion clinics to employ doctors who have admitting privileges at a local hospital. It's, a pretty stereotypical TRAP law. And I don't know if you want to go into what those are.
Sure. So TRAP laws, it's an acronym, so it's Targeted Regulations of Abortion Providers. So it's generally regulations beyond what is needed to ensure patient safety. So I would say this is a stereotypical TRAP law. They are designed to force clinics to close or be so expensive they force clinics to close. So admitting privileges sound, sure, of course the doctor should have admitting privileges. But hospitals don't just hand them out to everybody. You need to bring the hospital business, and sometimes they turn people down, not just for that, but for ideological reasons. So they're not about to give an abortion provider admitting privileges, or abortions are so safe, they are not sending people to the hospital, so the hospital has no incentive to grant them to abortion providers.
So who has admitting purposes is almost a political decision for these hospitals. I'm more familiar with this on the trans care side. I'm actually working on a piece about this. But yeah, I mean, I think that the perfect thing is what you just said is abortion is actually so safe that it's actually very rare for there to be a complication that requires admitting somebody to a hospital. So it's just a needless recommendation. And if something goes wrong for whatever reason during the administration of an abortion, they're going to send the person to the ER anyway. It's unnecessary. It's just unnecessary. And what ends up happening is you push control over the status of these abortion clinics into hospitals who aren't even affiliated with them and might have their own political agendas, right? And you actually have seen this recently, for a long time, but especially recently, where, hardcore Christians are pushing people into the medical profession in order to block up administration of reproductive health. And this would just be another way to build power for quote-unquote Christian objectors, right? So what happened was a couple of years ago with Whole Women's Health, this Texas law that was identical to the one in Louisiana was struck down by the Supreme Court with, I think, Justice Kennedy as the deciding vote, And basically they said this is an undue burden on, the right to an abortion because it would have closed, I think, the vast majority of the abortion clinics in the state.
It was almost all of them.
Yeah.
I think it would have left like 4 or 5.
Right, for a huge state like Texas. Yeah. And then in this Louisiana case, if it goes through, there will only be one abortion clinic for the entire state after this. So this is, again, an undue burden. Should be found the same way. There's clear precedence here. I think it's really, really troubling that they're taking it so soon after establishing the precedent in the first place. And of course, the big thing, you brought them up already with your emotional day. The only thing that's changed is Justice Kennedy is no longer on the court and Kavanaugh is on the court. And so what ended up happening was back in February, and I don't know the legal term for this, but I think they temporarily stayed implementation of the law while they reviewed the case. Kavanaugh wrote the dissent to that where he said, no, I would have let the rule. Yeah, I would have let the rule go into effect. So he's already signaling how he plans to vote. Yeah. Susan Collins.
Yeah.
My gut feeling is they want to overrule this. Or they want to overrule the precedent, and I think you'll see every state with a Republican majority implement this law right away. But there's if I could just go off the legal track for a second, it's interesting looking at what happened after Whole Women's Health came down. Is you actually saw a relative slowdown in implementation of trap laws in general while they said, okay, hold on, the court is checking us. Part of me wonders if that's why you ended up seeing so many 6-week bans earlier this year, because they didn't want to necessarily push on the trap law side. I think they decided enough is enough. We're going for big chunks now. And they've been pushed back on the legal front on the 6-week bans now. But I think that overruling Whole Women's Health, you'll see a return to just ridiculous trap laws going in all over the country.
Yeah, and it's so troubling and scary because this is the scenario where they could argue, well, Roe still exists. Roe is still the law of the land. It's Roe's still around. But if you are talking about enacting so many trap laws that there are no clinics, people have nowhere to go to get care. And your right to access abortion ceases to exist when you can physically no longer go and get one. If there is nowhere for you to go that is affordable, whether that means because now all of a sudden you have to take a day or 3 days off because the state you're in has a 72-hour waiting period. So you have to make 2 trips. You have to find childcare twice. You have to find transportation twice. This will put abortion out of reach of so many people who need the services, while Republicans will still be able to comfortably say Roe still exists,
right?
But people will no longer be able to access care.
Yeah. And I think that, I was there covering the Kavanaugh confirmation, and Susan Collins herself said, I don't think he'll overturn Roe. And she could be absolutely right and still remove the right to an abortion all across the country just by whittling down access all over the place. So it's incredibly frustrating to watch all of this develop.
Yeah, I'm really worried about what's going to happen. What can listeners do? We've heard all of this about, what's going on. Is there anything listeners can do at this point?
Yeah, continue to organize and push back. These laws are coming from state legislatures, right?
Yeah, absolutely.
And state legislatures can be replaced. They can be persuaded. I know that some states are more difficult than others, and there's gerrymandering and there's voter suppression. I think, again, I would say turn to elections and try to create elections that are as fair as we can create as we go along, and really try to push, the people who represent you to not implement these trap laws, right? And educate the people around you about what trap laws are and why they're so pernicious. I did a tour a couple of months ago in Philadelphia of an independent abortion clinic, and they were saying how state law required them to install like $100,000 HVAC system for their recovery room, which is totally unneeded. And they had to go up through the roof, and it was in there was like 3 floors above them. And it's just an example, again, of one of these trap laws. They were hoping that the clinic's landlord would be like, no, you can't, run a ventilation system to the roof that's separate from the other ventilation system that we've already provided you, right? And this is how they just block up the system for providers. And I don't think people are aware of this stuff.
No, it's under the innocuous name of it needs to be a certified ambulatory surgical center. Again, it sounds innocuous, right? But it requires all of these upgrades that are designed to be so expensive that it forces the clinics to close.
Yeah. And I think there's a lot of stigma and misinformation around abortion. It's actually a really simple procedure. People have been performing abortions since the beginning of time, right? It's not, listen, I've had gender reassignment surgery. That is a major surgery. I was in the hospital for like 9 days. Okay. Like that was a big deal. Abortion is not a big deal compared to that. Like, obviously there's an emotional component to these things, but we're not talking like medically. It's not as big or as harsh as like the antis make it out to be, especially if it's just like a medication abortion, right? Or just like, you could do it with a hand pump. Really, it's just not. Sorry, I'm just getting angry now.
Sorry, this is my job. I get to make everybody angry. I'm a real joy to talk to because everyone's like, "How's work?" And I'm like, "Let me tell ya." So, I'm fun at parties and stuff. Okay, so that's what you can do on abortion. I think we already talked about what you can do around LGBTQ stuff, and that's call your senators and tell them to support the Equality Act. Yeah,
and I think another thing, too, that's underrated that just an average person can do for LGBT issues is make sure your employer is on top of this stuff. Like, ask your employer what their policies are on LGBT people. Is your health insurance plan trans inclusive? If you create a welcoming employment place for a trans person or an LGBT person, which I think is easier to do these days, you can lower the impact of a negative ruling just on a micro level. So I would say, don't be afraid to ask tough questions of your employer and be like, hey, what are we doing? Like, does our health insurance plan include, trans health? Does it include abortion? Because that's another question that comes up, especially if you work at Hobby Lobby and...
and abortion may be defined as an IUD.
Right.
Sorry, that was a huge eye roll for, the non-visual media.
We both eye rolled.
Okay. Katelyn, thank you so much for doing this. As always, it was a joy to talk to you.
Thank you so much.
Thanks for listening, everyone, and we'll see you on our next episode of rePROs Fight Back. For more information, including show notes from this episode and previous episodes, please visit our website at reprosfightback.com. You can also find us on Facebook and Twitter at rePROs Fight Back. If you like our show, please help others find it by sharing it with your friends and subscribing, rating, and reviewing us on iTunes. Thanks for listening.